We're going to start again. Unfortunately, because of time constraints, we're going to have to hold the questions on Susan's topic and move to our 10:30 to 11 o'clock, 11:10 block, which is our Dora, Nipp, and Kikee Malik from the Human Rights Commission. We're kind of going to shrink the topics down by 5 or 10 minutes and try to leave some time at the end of each presentation for questions. I mean, we apologize that we're not going to probably get to all the questions, and unfortunately that's an important part of a program like that, but we're simply running out of time. Perhaps on reflection we might have made it a day, but we're with a half a day, and I'm sure everybody's got time commitments elsewhere. Anyways, I won't speak any longer, but simply move to the next item on our program, which is handling a sexual harassment complaint before the OHRC. And we've got Dora Nipp, who's a policy analysis with the Commission, and Kikee Malik, who's legal counsel. And I'm going to turn it over to both of them. I don't know who's going to talk first, but take it away.
Good morning. In preparing for this seminar, I had somebody at the Commission put together some stats for me as to the number of sexual harassment complaints that have been filed with the Commission over recent years. Starting in 1982, 1983, which would be our first fiscal year after specific grounds for sexual harassment were included in the code, there were approximately 99 complaints that were filed with the Commission. The number steadily increased till 1990-91 to 157 complaints. In the 91-92 year, however, this number drastically jumped to 256 complaints. And I was trying to think for a reason as to why during those 2 years that the number had increased at such a drastic rate, and it brought to mind the Anita Hill and Clarence Thomas hearings in the United States, and I found it interesting that sexual harassment was never really an issue when it threatened the careers of millions of women, but it seemed to become a major issue when it did threaten the career of one man. So I leave that as a personal aside and begin. A portion of the paper which Dora and I included in our materials is a general overview of the Human Rights Code and a brief description of the complaints process. The Commission has put together a procedures manual which is available through our Communications and Education Department. That manual goes into a much greater detail about the complaint, investigation, settlement, and conciliation process and procedures that the Commission utilizes. So if you feel that the materials that we've provided are only a thumbnail sketch, then I would encourage you to contact the Commission and ask for a copy of the procedures manual. At this point, I would like to focus on certain elements of the complaints process at the Commission, which I feel are important for Council to be aware of. The first relates to the jurisdiction of the Ontario Human Rights Commission. The Commission may lack the jurisdiction to proceed with a particular complaint against a respondent company if that company is engaged in activity that's regulated by the Parliament of Canada. In these type of circumstances, an officer or staff at the Commission will carefully examine the features of the company's operations to determine whether the complaint that has been brought before them is one that is properly handled by the Ontario Human Rights Commission, or whether it is one that should be handled by the Canadian Human Rights Commission, and will then direct the complainant accordingly. There are essentially 2 processes by which a complaint is dealt with at the Commission. First is the Early Settlement Initiative, which is referred to as the ESI process. The second then is the formal complaint process. The ESI process is an early and informal way of dealing with an individual complaint at the Commission and will take place without a formal complaint being filed. What will happen is when a prospective complainant comes to the Commission, the staff will ask them questions to determine the possible applicability of the ESI process. If it's determined that the ESI process is one which would be appropriate for a particular fact situation, then a preliminary investigation will be conducted by an officer. This will usually involve interviewing the complainant, making inquiries of the respondent company and the alleged harasser, and to try and review any documents which may be relevant in a particular circumstance. The parties are then allowed to essentially tell their side of the story to the officer, and disclosure of each of the parties' position occurs. The officer then tries to mediate a resolution to the complaint by mutual agreement between the parties within a certain set time frame. What will happen is that if it is found that an ESI is not working, then a formal complaint will be filed, and you move then into the formal complaint process. An early resolution of many complaints can be advantageous to both the complainant, who may be able to gain access to a remedy that is not available at a later point in time. The ESI process is also advantageous to many respondents whose potential liability may be limited because they're able to reach an agreement with the complainant within a short period of time. Again, it depends on a particular fact situation or the circumstances of a complaint to decide whether an ESI process is appropriate. If you're dealing with a sexual harassment complaint where the employer is a small company, maybe operating a family business where there are only 2 or 3 people that work there, and a secretary is complaining about sexual harassment, a lot of times ESI is not the appropriate forum when it is the employer and the employee who happens to be, if it's all a family business, everybody's going to stick up for one another, and an ESI is not going to allow any type of mutual agreement to be reached. Sometimes if you have a large corporation, an ESI may be possible when it's a single coworker who is harassing another coworker, and once the situation is brought to the attention of an individual higher up in management, they are able to effectively deal with the situation, and the matter can be resolved in a short period of time. If it's decided that an ESI is not the way to go, then we get into the formal complaint process. The formal complaint requires a formal response. Respondents who receive the formal complaint form from the Commission should take this step seriously and should involve counsel at this point in drafting a response to the complaint. As Commission counsel, we are often surprised by the number of responses that we receive in return to complaints that have been filed by members of senior management, even when the large companies do have in-house counsel that they can approach. It's important that the response is drafted carefully, because if the complaint goes forward to a board of inquiry, the response is often used as evidence at the board. The next area I want to talk about is Section 34 of the Code. The Commission cannot refuse to take a complaint. However, under Section 34 of the Code, it does have the discretion to not deal with a formal complaint. Section 34 of the Code outlines the various categories under which the Commission can decide to not deal with a complaint. If in your position as possible respondents counsel you feel that there is a valid reason under Section 34 that a complaint not be dealt with, as counsel you should write to the officer, explain your position, and then ask that the Commission make a decision pursuant to Section 34 to not deal with the complaint. Some respondents' counsel will utilize this provision routinely. As soon as their clients get a human rights complaint in, they will automatically send a letter to the Commission requesting that a Section 34 decision be made. Practically, the Commission will not refuse to deal with a complaint except for very cogent reasons. So if you are responding to a request by your client to have the complaint not dealt with, that there should be good reasons, otherwise the Commission is not going to grant the request. Some of the examples of the provisions under Section 34 are Section 34 1A, which states that where it appears to the Commission that the complaint is one that could or should be more appropriately dealt with under another act. An example like this is a complaint that's received that is essentially a pay equity complaint. The Ontario Human Rights Commission will have an overlapping jurisdiction with the Pay Equity Commission, and the commissioners may decide that the complaint is one that is more effectively dealt with through the processes of the Pay Equity Commission, and will then make a Section 34 decision to not deal with the complaint and ask that the complainant refer or continue with a process that they may have already undertaken through the Pay Equity Commission. Section 34 1B deals with complaints that may have been made in bad faith or are trivial and vexatious. A lot of times this section will be utilized if an internal settlement has already been reached between a complainant and a respondent company, and the complainant then comes to the Commission. If the Commission feels that the complainant has already received an adequate remedy through an internal settlement that they have reached, then they will utilize the provisions of Section 34 1B. If, however, the complaint is dealt with, then the next thing that will happen is that an investigation will take place. There are certain things to be aware of in terms of the human rights investigation. First, pursuant to Section 33 of the Code, the Commission has broad investigative powers, and usually respondents should be guided by counsel as to the provisions of Section 33. During the investigation, the Commission should be acting as a neutral agency and not as a prosecutor. And if a respondent does not cooperate with the Commission during an investigation, the Commission, again under Section 33, can request the automatic appointment of a board of inquiry, or they can also apply for a search warrant. At the end of an investigation, an investigator will prepare what's called a case summary, in which they will review the major findings of the investigation. The officer will also make a recommendation to the commissioners as to whether a board of inquiry should be appointed. The case summary will be disclosed to both the complainant and the respondent. Both complainant and respondent then have the opportunity to respond to the case summary and in writing, and the responses that they make to the case summary will then be put forward to the Commission before they make their determination as to whether the complaint should go forward to a board of inquiry. The board of inquiry, which may be appointed on any given complaint, will hold a formal hearing. The hearing process is governed by the provisions of the Statutory Power and Procedures Act. At a board of inquiry, it is the Commission that has carriage of the complaint, and the Commission does not represent the complainant at a board of inquiry. Complainants are allowed to have separate counsel and are advised to do so before they appear before a board of inquiry, and it is the responsibility of Commission counsel at a board of inquiry to represent the interests of the Commission and to represent the interests of the public at large. If at a board of inquiry it's proven that there has been a breach of the code, a board has broad remedial powers and can order both special and general damages, reinstatement, the institution of special programs. It's clear from the code, and I'll just quote the section, where the board has found that a right of the complainant has been infringed, the board can direct the party to do anything that, in the opinion of the board, the party ought to do to achieve compliance with the Act. This is a clear intention on the part of the legislature that encourages boards to be very creative in the type of awards that they hand down. There are some of the type of examples of board orders that have been made in the area of sexual harassment include a requirement that a male employer who has found to have sexually harassed a female employee report or notify the commission for a period of 2 years after every time a female employee leaves, and to state the reasons why that employee is leaving the company. There are considerations for general damages in harassment cases that include the nature of the harassment, the frequency of the harassment, and the psychological impact that the harassment has had on the employee. Those are guides for boards to consider in determining general damages to award to a particular complainant. Okay, I'll hand over the rest of the program to Dora Nipp, who is from the policy department. She'll explain some of the aspects of the policy paper which the commission is putting together on gender-related harassment. And at the end of Dora's session, we'll take questions. We've just given you a thumbnail sketch of the human rights process. There may be specific questions that people will have, and those are better dealt with through your questions than through my comments.
Good morning. Can you hear me? The Research and Policy Unit has just completed a draft policy statement on inappropriate gender-related conduct and comment. So what I will do is take you through the policy statement. It consists of 10 sections. The first is the introduction, followed by the purpose of the policy statement, definition of harassment under the Human Rights Code, with specific reference to provisions dealing with vexatious conduct or comment, sexual harassment or solicitation, and reprisal. Part 4 deals with poisoned environment. 5, inappropriate gender-related comment or conduct. 6, burden of proof and evidentiary issues. 7, employer's liability, dealing with the subsections of harassment and poisoned environment. 8, human rights remedies under the code. 9, filing a complaint. And 10, speaks to collective agreements and company policies. So starting at page 1, you'll see our introduction. Inappropriate gender-related comment or conduct is a form of discrimination that tends to emphasize or define a relationship where the parties are viewed as unequal simply on the basis of gender. This is an unacceptable form of behavior, and it's contrary to Ontario's public policy. And that is to recognize the dignity and worth of every person and to provide for equal rights and opportunities without discrimination. Inherent in this is that members of groups protected by the code can live and work in an environment which is free of demeaning comments and actions that are related to gender. The purpose of our policy statement is to set out the Commission's interpretation of what is meant by inappropriate comment, gender-related comment and conduct. What it attempts to do is to distinguish between what is accepted social interaction or consensual relations from those in which an individual is required to contend with unwelcome gender-related actions or demands in the workplace, in housing, or with respect to the provision of services. Harassment is defined under the code. You'll find that at page 2. It sets out the provisions, so I'm not going to repeat them. Sections 1, 2, and 5 of the code deal with basic equality rights, and there are also specific provisions dealing with gender-related harassment in accommodation and the workplace. The general principles of harassment are found at page 5 of your paper. And specifically in the area of employment, the code provides that all employees have a right to freedom from harassment in the workplace by the employer, the employer's agent, or by another employee because of gender. Harassment is defined in the code under section 10(1)(f) to mean engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. Now, of course, each situation will be judged on its own merits, but the reference to comment or conduct that is known or ought reasonably to be known to be unwelcome It does import an objective element into the definition of harassment. It acknowledges that in some situations, there should be anticipated that gender-related comment or conduct that would be offensive or unwelcome. You should also be aware that there's no requirement that this behavior be objected to before a violation of the code is found. But the test is not entirely an objective one, because the objective standard has traditionally been seen from the perspective of the harasser. So the standard that the Commission adopts is that of the reasonable victim, and we use victim for lack of a better term at this time. That is, it should be framed subjectively in terms of a reasonable person having the perspective of the complainant. And that brings into the factors which Mary Cornish brought up earlier, cultural factors, etc. A course of generally refers to more than one event in order to establish harassment. However, persistent and frequent harassment is not required in order for an adverse finding under the code. Depending on the severity or the impact on the complainant of the comment or conduct, one instance may create a poisoned environment, and that constitutes harassment under the code. Section 7.3a declares a person's right to be free from any advancement or solicitation made by a person in a position to grant or deny a benefit to another. An example of that would be unwelcome advances from a professor or a teacher to a student, from an employer to an employee. Reprisal is dealt with under Section 7.3b of the Code, and it provides protection against prohibited behavior that occurs when a person who's in a position to deny or grant a benefit threatens or institutes a reprisal against another who rejects his or her sexual advances. An example of that would be an employee denying an employee promotion because the employee has refused sexual proposition. I'm going to skip over now to poison environment, which you'll find at page 7. Now, it's the Commission's position that offensive or threatening comment or conduct may in some instances have the effect of poisoning the environment for persons affected. Now, as I stated earlier, technically, one instance does not fall within the definition of harassment unless it poisons the environment. The Commission looks at the impact of the comment or conduct on the individual rather than the number of times it occurs. And an example of a single action instance would be where a supervisor expresses the belief that women do not belong in the workplace. Now, persons who aren't specific targets of the discriminatory action or comment, or who aren't members of the targeted groups, may also have the right to bring a complaint in similar circumstances. This is based on the principle that exposure to such treatment has a negative impact on the sensibilities of that individual. And an example would be a man may be offended by the treatment of women in the workplace. At page 8, we deal with inappropriate gender-related conduct or comment. And this type of behavior may be overtly sexual in nature, in which it is demeaning, belittling, humiliate, or cause embarrassment to the individual. But then again, it may not be overtly sexual. It may be related to a person's gender. For example, harassment that amounts to degradation of a person of that gender. And Mary Cornish gave the Shaw example earlier on of repeatedly referring to a woman as a cow, or in that instance as well, as a complainant walked by the respondent, he would say swish, swish, swish as she walked by. This type of behavior may occur between men and women or persons of the same sex. It can be directed by women towards men. And it often involves using power to import sexual requirements into the workplace. Inappropriate gender-related comment or conduct includes, but are not limited to, verbal behavior, gestures and nonverbal behavior, visual materials, and physical contact. And you'll find further examples of that on page 9 of the paper. You should also be aware of more subtle forms of reinforcing the male power dynamic. That is, even in the best intentioned compliments regarding a woman's compliments regarding, say, a woman's appearance, her hair, her dress, etc., made on a repeated basis in the work environment or, for example, in a formal business meeting, can be undermining to the woman's credibility as a professional employee. And this may poison the environment for her as well as others. I'll turn briefly to the burden of proof and evidentiary issues, which you'll find at page 10. Very quickly, Kikee dealt with this actually. The complainant and the Human Rights Commission have the onus of proving sexual harassment on a balance of probabilities. Now, because sexual harassment does not often occur in public view, there may be no witnesses, in which case the credibility of the parties, or the case would turn on the credibilities of the parties. And where credibility is at an issue, similar fact evidence may be introduced. With respect to employer's liability, which is found at page 11, this was addressed earlier by Mary Cornish, but I'll go through some points very quickly. The acts of supervisors, managers, etc., are considered to be acts of the employer. It's illegal for any condition of employment, which includes hiring, salary, promotion, termination, etc., to depend on a positive response to the supervisor's advances or requests. On being made aware of such conduct, the employer is required to take immediate and appropriate remedial action to correct the situation. That may be in the form of an oral or written reprimand, suspension, demotion, transfer, or dismissal. Legislation also imposes a positive duty on employers to provide a safe and healthy work environment. Where it comes to the employer's attention that the terms and conditions of employment differ for reasons related to the employee's gender, the employer has an obligation to immediately and adequately remedy the situation. Page 12, you'll find human rights remedies under the code. Now, the purpose of human rights legislation is to remove discrimination, and therefore its remedies tend to be remedial rather than punitive. Remedies may include restoring the complainant to the position that he or she would have been in had the code not been violated. This may include specific and general damages and must also address the public interest component. Filing a complaint, which is in our policy statement, which is not in your paper, was discussed earlier by Kikee. And finally, the policy statement deals with collective agreements and company policies. There's an increasing number of collective agreements that include clauses relating to discrimination and harassment. And similarly, a number of companies have implemented policies which do afford a remedy to persons who've been harassed or discriminated against. Should note that parties cannot contract out of the code, and neither a collective agreement nor a company policy precludes a person from pursuing his or her rights under the code. Just to conclude, the Commission has prepared guidelines for internal human rights complaint resolution procedures, which are included in the package. And you'll probably find this useful in assisting your clients in preparing their own internal policies. And as a final note, the Policy and Research Unit does review, on written request, draft policies. So if there are policies that you have, you're more than welcome to send them to the Commission. But please don't send them all at once, and don't expect to have a week's turnaround, because they do take time and we are understaffed. But you are welcome to contact us at any time.
Thank you. Questions?
Do you have any, in light of what you just said, any pro forma kinds of policies that you might provide to us as a working draft?
Let me repeat that question. The question was, does the Commission have any pro forma forms that they could use in terms of policy and matters such as that?
We do have the internal complaint procedure guidelines, which explain to you what should be included in your policy and how the policy should be drafted.
That's in the handout.
That's in the handout.
Do you have figures on how many complaints actually get to the board of inquiry stage?
The question is, are there figures for complaints that actually get to the Board of Inquiry stage?
I assume that you're talking about sexual harassment complaints. I know that we do have statistics as broken down by the prohibited grounds on the number of complaints that are filed. Whether or not we have comparable statistics in terms of a breakdown by prohibited ground of the cases that go forward to boards of inquiry, I'm not sure. We do have a case management team at the Commission, so I think that they would compile statistics on that basis. Whether or not they're broken down in terms of prohibited ground, I'm not sure.
David?
In the event that a complainant signs a release, the employer saying that she will pursue a complaint with the Rights Commission, was mentioned here the fact that she can't contract out of the code. How would an employer face the argument that having signed this complaint, the employer is nonetheless still liable?
Okay. I'll repeat the question. The question is, having obtained a release from an employee that would release a claim based on the code, I assume, the question is, how does an employer face the question of I guess, dealing with settling cases when in fact there is, I guess, a position that you can't contract out of your rights under the code?
I think that the way that those two issues are dealt with at the Commission are that they are different concepts. If a complainant has signed with their employer a release stating that for a particular remedy that they will not file a human rights complaint, and if they do subsequently file a complaint, then often that will be dealt with under Section 34 of the Code. And if the Commission is aware of that beforehand, they can send it up to the Commissioners on their own. Section 34 requests are not only dealt with at the request of the respondent. If the officers are aware that a release has been signed with information that the release contains a provision that they not file a human rights complaint, that it can be dealt with under Section 34, which is a decision not to deal with the complaint because the complaint was made in bad faith. We will, however, examine the circumstances around which the release was signed in terms of whether the complainant had independent legal advice, you know, whether there was any pressure exerted on them to sign the release and things of that nature. But in many cases it will be dealt with as a bad faith complaint if they were aware that they were signing a release that indicated that they could not subsequently file a human rights complaint.
Right behind.
Yes, with respect to the case summaries, what happens to the case summary and the recommendation in between the time the Commission decides whether to appoint a board of inquiry?
The question is,
Every summary does those. Every recommendation, positive recommendation.
the question is, what happens when a case summary, I assume, goes up to the Commission with a recommendation to appoint a board? Does the officer's recommendation usually always get adopted, or what's the Commission's, I think, record in deciding to appoint boards of inquiries based on case summaries?
Well, what the Commissioners will see is the in what's called the Commission package. They will see the case summary. They will see the response to the case summary, if any has been filed by the complainant and the respondent. Sometimes there will be legal opinions that are provided on the case, policy papers or systemic papers. They will review the Commission package, and under Section 36 of the Code, if the Commissioners feel that the evidence warrants the appointment of a board of inquiry, they will then request the Minister to appoint a board of inquiry. Now, in past years, in terms of statistics, the Commissioners have been appointing on average 25 to 30 boards of inquiry per year. At this point in time, we're just halfway into our fiscal year, and the set of Commissioners that are with the Commission now have appointed, I believe, close to 100 boards of inquiry. So a lot depends on the Commissioners that are sitting and any particular agendas that they may have in terms of cases that they want to see go forward, and as well the number of complaints. We've also, the number of complaints that have been filed with the Commission have increased.
Can I just?
With all due respect, that doesn't really answer the question.
Can I just add to that?
How many recommendations for action came out of the board of inquiry? In other words, is it just routine to appoint the board of inquiry, or are there cases that are turned down?
No, there are cases that are turned down. If the investigation has revealed insufficient evidence, then the Commissioners will not appoint a board of inquiry. In terms of numbers, I can't give you any numbers as to how many go through and how many don't.
But let me just, maybe I can, I think what the question is trying to get at is, the report goes up with a recommendation to appoint a board. I mean, does the commission de facto act as a rubber stamp when there's a recommendation from an officer to appoint, or do they exercise some independent judgment or calls to say, we disagree with the case officer here and we're not going to appoint?
Can I just add to that, please? After case summary is prepared, what happens before it goes to the commissioners is that there's a meeting of the directors, and each unit goes through a case. They comb through it. For example, our policy unit will attempt to ensure that all the policy issues are addressed. The systemic unit ensures that all systemic issues are addressed. Even if the officer makes a recommendation for a board or no board, if there's evidence missing or issues that have not been addressed, it goes back for either further investigation or to the officer to pull that information out before it goes to the commissioners for a final decision. So that it is vetted by the directors before it proceeds to a board or to the commissioners for a decision.
Any other questions?
The board keep a record of performance of the employer, or for example, a complaint is made and the employer decides it's going to cost $5,000 to get rid of this complaint by payment to the employee, and it's going to cost 3 times or more to the defendant. And they make a business decision to pay the $5,000. Now, is there a record being changed to further complaint a year or so later?
Okay, I have to repeat that question for the recording. The question is, does the commission keep a record of I guess, in this case, settlements or findings by boards of inquiry against specific employers? I.e., and just a follow-up question, if it does, how does it use it?
Well, I think there are databases that are kept as to respondents and complaints that have been filed. There's also a provision in the code to monitor whether it's employers or the employer as a harasser in terms of repeat offenses, if you want to call it that. In terms of an employer who wants to settle, the commission as a party before a board of inquiry will also make sure that the public interest is also settled, as opposed to any compensation that will flow to the complainant. So if they feel that there are things that should go in place in terms of sexual harassment policies, the commission will try and negotiate that as part of the settlement as well, and will not only let a settlement occur between the complainant and the respondent that does not address some of those larger issues of policies that should be in place to possibly prevent a repeat occurrence of possible harassment in the workplace.
One more question. Right there.
Yes. You gave a rather clear example before of what constitutes a bad faith or trivial or vexatious complaint. Can you give an example that's maybe not as clear-cut, and what kind of procedures are used to decide whether it in fact is a vexatious claim or a trivial claim?
Yeah, let me just repeat that. The question is, could you give some more specific examples of what the commission might consider to be a vexatious or bad faith claim, and what's the process that the commission uses to make that determination?
Usually the commission will not be able to make a determination unless there is some, at least preliminary investigation that's done. In terms of sexual harassment complaints, as far as I know, that provision will not be used that often in terms of finding that a complaint is either trivial or vexatious. If anything, they may rely on the provision of a bad faith complaint if they feel that there has already been an internal settlement with regards to that. Usually, there may be examples of vexatiousness or trivialness in terms of other types of complaints, but in terms of sexual harassment complaints, it's not something that we usually deal with. A lot of times we'll get a request from a respondent to make a determination under that provision of the code to say that this is a vexatious complaint, but often because there are issues of credibility that are involved, the commissioners feel that that's a determination that's best left to a board of inquiry and not to the commissioners.
Okay, I think we're going to have to bring this part to a close. Thank you, Kikee and Dora, for helping us on how the commission works in respect to these types of complaints. And while you're standing down, I'll take a minute to introduce our next speaker. When I spoke to Norm Grossman beforehand, he asked me to advise the listeners that he thought it was somewhat unfair that I had asked him to do the most difficult topic. And I think, in fairness to Norm, that's probably correct, because we're now moving into something that we all understand and deal with, which is the Commission and their various policies and practices, into an area which is an ongoing landmine for employers, which is the role of the courts in sexual harassment. And I should say, just from my own personal practice perspective, from a victim's or a plaintiff's side, see the courts as more and more of a very real opportunity to get these matters resolved, because of the point that Mary made relating to the speed at which at least the Ontario Commission can react to solving the matters. However, having said that it's a potential way to deal with them, there's certainly legal roadblocks in the way. And Norm's going to take you along how to be creative in dealing with these matters.
Well, first of all, I thank you, John, for the disclaimer. You're obviously a very gifted advocate. Truth in advertising, as many of you probably appreciate, one of the most difficult things you come across in agreeing to participate in this type of event is creating a paper. And when I sat down to deal with that task in August, I had a dilemma as to whether to devote somewhere between 50 and 100 hours of research to looking at what American authorities existed on the subject, or whether to stick with the Canadian authorities, which are few and far between. I had a sudden surge of nationalistic feelings, which I like to believe is not a coincidence. You'll recall the unity debate was going on at that time. But what the result is a paper before you which I hope is thought-provoking, but which unfortunately leaves a lot of questions at the same time as I hope provides some answers. The first and basic proposition which we have to accept in order to understand what civil remedies can exist is that individuals have the right to be free from sexual harassment in the workplace, and I think that's a pretty basic proposition, and we know that from the Ontario Human Rights Code and the Canadian Human Rights Act. My talk really focuses on the external procedures which complainants or individuals who feel they've been harassed can avail themselves of. And in the event that somebody feels they are the victim of sexual harassment in the workplace, aside from the avenues which Mary Cornish mentioned, I believe there are really three ways to approach it. The first, which I'll touch on very briefly, is through the human rights legislation. The second is what I'll call a creative approach in using the common law. And the third is simply a combination of the first two. To deal with the human rights legislation, and that's both on the Ontario and federal level, each legislature has passed legislation which deals with the issue of sexual harassment, has created a comprehensive administrative scheme to deal with it, and has provided a whole array of remedies. This, I think, can be thought of as the conservative or traditional approach to a sexual harassment complaint, and that is one of the advantages of proceeding in that direction. It's where the statute is clear, it's where the legislature intends you to proceed when you have a sexual harassment complaint in the workplace. And the second potential advantage is it's a high-profile type of approach if not in the media, and although complainants like to think that their case is going to splash all over the front page, that's not necessarily the case, but it's high profile from the corporation's perspective, and it can attract a lot of interest in terms of corporate reaction and can be a tremendous lever in terms of an early and successful resolution. The disadvantages to proceeding with the human rights complaint, as we've heard, are that the procedure is not as expeditious as everybody would like it to be. Relief comes slowly and painfully in my experience, and complainants often lose their momentum in the process and correspondingly their interest in the process, and the whole thing from the employer's perspective can die a natural death with the passage of time. And that leads me then to consider the more creative approach, the second approach to dealing with a sexual harassment claim. I think it requires two elements in order to proceed with a creative approach. First, I think is obvious, you need creative counsel. And the second thing I think you require is a compelling fact situation. It's not every allegation of sexual or gender harassment in the workplace which lends itself to a creative approach. When I talk about a creative approach, I want to divide that into two sections. I want to talk about a really creative approach and a traditional creative approach. And when I think of a really creative approach, I'm talking about you as creative counsel taking that compelling fact situation and attempting to craft a new cause of action out of the statutory prohibition against sexual harassment. And that seems to me a very logical approach. You've got the statute which says this type of conduct is prohibited. I've got a client who says they're the victim of that type of conduct. There's got to be a remedy. There's got to be a cause of action. The common law has to provide an answer. The problem is the case of the Board of Governors of Seneca College of Applied Arts and Technology and Badaria. And we have come to call that the Badaria decision. And in that decision, a young woman of East Indian origin who had a PhD, valid teaching certificate, 7 years of teaching experience in mathematics, applied for a teaching position that was advertised by Seneca College. She applied on 10 separate occasions, and while she was assured that she would get an interview, she never did, and she alleged that the position was ultimately filled by somebody who was less qualified, and that's an easy conclusion. Probably most of us in this room are less qualified than she was. She commenced a civil action in addition to a human rights complaint, and the civil proceeding was based on a new intentional tort to provide damages for the unjustified invasion of her interest not to be discriminated against in respect of prospective employment on the grounds of race or national origin. It became the subject of a Rule 126 motion, for those of us who were around in the days of 126 motions, and worked its way right up to the Supreme Court of Canada. And the Supreme Court of Canada looked at this really creative approach, one of crafting the cause of action out of the statute and the prohibited ground, and said, just a second, the Ontario legislature has provided this comprehensive administrative scheme with investigative procedures and remedies, and let's not forget there's a right of appeal to the courts in any event. And kind of ironically, they patted the Court of Appeal on the back, which had allowed this cause of action to exist for a time, and said that was a very bold attempt to create a new common law cause of action, and in fact actually said you're to be commended for that attempt, but your attempt's going to fail because the common law cannot take its life out of a statutory prohibition directly, and if that common law cause of action doesn't already exist, you're going to be precluded from pulling it out of the statutory enactment. So the message, I think, from the Badaria case is creative counsel who are faced with that compelling fact situation have to keep their creative juices under control, because if you try and pull that cause of action out of the statute, you're likely to be faced with a motion under Rule 21 that your claim discloses no reasonable cause of action at law. Let's then look at what I'll call the traditional creative approach, which is to take a cause of action which we know at common law and apply it to that compelling fact situation. The examples which I use are, and ones which readily come to mind, are constructive dismissal. And I think that, at least in theory, and there are a few cases which have gone forward with an allegation of constructive dismissal based on sexual harassment, there's no reason why that type of claim cannot succeed. I think the argument can be made that it's an implied term of every contract of employment, particularly given the legislative prohibitions and background, that I, as an employee, coming to your place of employment, have a right to expect a workplace free from an environment in which I will be sexually harassed. And if I am the subject of sexual harassment, and particularly if you do nothing about it as my employer, then you have repudiated an implied term and a fundamental implied term of our contract of employment. I've been constructively dismissed. And that can either occur because of an argument that it's a poisoned work environment, or because I'm making the argument that somebody in a position, a superior position to me, is exercising control over me on the basis of harassment or sexual solicitation. There's no successful decision on the point yet. There are a couple of cases referred to in my materials. The Gosh and Domglass case is one where there was an allegation of constructive dismissal. The Meeklum and Bot Limite case is one where there's an allegation of sexual harassment. And I think those are going to go forward, and there may well be a finding. I'll come in a moment to the problem that creeps up when you then introduce a human rights complaint at the same time. The other approach you can use in terms of a traditional creative approach is to look at intentional torts. There's no reason, in my view, why an intentional tort and a known common law cause of action cannot be applied to the right, compelling fact situation of sexual harassment in the workplace. And the types of intentional torts which come to my mind are assault, battery, intentional infliction of mental suffering, maybe a little more remotely conspiracy, inducing breach of contract, and any of those intentional tortious actions are certainly within the realm of possibility and have been joined with actions for constructive dismissal. The Meeklum and Bot Limite case is a good example, and that's a case which is being handled by John's firm. The complainant was on a road trip with her boss, and they were staying at a relax inn, and he made certain amorous advances towards her on that trip, and she complained to management, who did nothing about it, and as a result, she said, I can't work in this environment anymore. I've been constructively terminated, and joined that with an action for assault and battery because there had been some touching and feeling going on. The third type of creative traditional approach is, as one of the earlier speakers said, I think it was Mary, to consider a breach of fiduciary duty. That's an area of the law which is rapidly expanding. In my view, judges are welcoming the opportunity to consider the area of breach of fiduciary duty and to expand it. And I think that there is a fiduciary duty which exists between a person in an employment relationship who is the superior and the subordinate who is in a vulnerable position, vulnerable to the discretion and the exercise of discretion of the superior. And acts of sexual harassment in the right and compelling circumstances could certainly be construed as a breach of fiduciary duty. The real problems start if you attempt to join one of these traditional creative approaches, constructive dismissal, assault and battery, whatever it may be, with a human rights complaint. And it doesn't really make a difference whether you start your action first and then file a human rights complaint, or you file the human rights complaint and then start your action. That's where the courts have indicated with reluctance that they're prepared to step in. The first real case in the line of authority, which is still in its infancy but clearly on a track, is Gosh and Domglass, where Mr. Gosh alleged constructive dismissal and filed a human rights complaint. The employer went to court to obtain a stay of the human rights complaint, and Madam Justice McKinley expressed 3 particular concerns about these 2 methods of redressing an alleged sexual harassment proceeding in tandem, side by side. Her first concern was that if the 2 matters proceeded on separate tracks, that is the human rights complaint and the common law cause of action, there would be a duplication of evidence on identical facts. Her second concern was the possibility of 2 different tribunals coming to 2 different conclusions on the same set of facts. And her third concern was the possibility of double recovery, which would be unfair to the employer. And as a result, she granted a stay of the human rights complaint pending, a stay of the civil proceeding pending the disposition of the human rights complaint. More recently, that decision was considered in the Meeklum and Bellamy case, and Mr. Justice Summers, who took some time to address exactly where the human rights complaint was at and express his concern about how slowly that process was moving, ultimately said, I've got to share the same concerns of Madam Justice McKinley, and with great reluctance stayed the civil action for constructive dismissal and assault and battery, and said, the second that human rights complaint is done with, one way or another, this common law cause of action is reborn and comes to life again. But in the meantime, with great reluctance, I grant you, the employer, your stay. Another case where the Gosh and Domglass decision has been followed, which isn't in the materials, is a decision in Spearing, S-P-E-A-R-I-N-G, and Canadian Imperial Bank of Commerce, which was decided last fall, where Mr. Justice Mandel granted a stay again on the basis that the human rights complaint and the civil cause of action were proceeding in tandem. And I'll let you in on a secret, there's going to be another decision on this point in about 2 weeks, because I'm involved in it, and the site is going to be Mona Omar, O-M-A-R, and Canadian Imperial Bank of Commerce, because the same issue has come up again in terms of the complainant having filed the human rights complaint and proceeding with a civil action at the same time, and we're going to move for a stay of the civil action. So the message from the courts is that you have to choose your remedy and choose it carefully, because if you attempt to go both ways, I guess the only advantage to doing that is preserving limitation periods, because you may well meet the argument that your civil cause of action should be stayed. As an addenda to those points, there is a particular provision in the Canada Labour Code, which is at page 7 of the materials, which provides that a procedure for redress that has been provided elsewhere in or under the Canada Labour Code or any other act of Parliament must be followed in preference to an unjust dismissal complaint, which is the federal companion of a wrongful dismissal action. And if you're acting for a federal employer, and if there is a human rights complaint at the same time as an unjust dismissal complaint is proceeding forward, in my view, there's a statutory prohibition. There's a requirement that the individual proceed with the human rights complaint, avoid the unjust dismissal, treat that as the remedy of last resort, and that's going to tie them up through the Human Rights Commission and the procedural problems and the backlog. The other addenda point is the irony of this area of sexual harassment, which we all perceive as developing rapidly, but it's developing at the same time with a number of procedural barriers. The one area where it doesn't seem to run into procedural barriers is when sexual harassment is used as a defense rather than as a cause of action. And employers are the beneficiary in this sense of the development of the law, and have used successfully the defense of sexual harassment as being cause for termination of employment in a number of scenarios. You have to be very careful, of course, when you make that kind of serious allegation that you can prove your point. There's a reference to Hughes and City of Etobicoke in the materials. You're dealing with a 38-year employee who's close to retirement and an allegation of sexual harassment. One ought to be very careful about making that kind of serious allegation in those types of circumstances, or it could cost your client $180,000 like it cost the City of Etobicoke. On the other hand, to contrast that with another decision which is in the materials, Mackey and Ginesco, that is a response of the court which I would expect in the instance of established sexual harassment. The judge said, how in the world could this company continue to employ a man like this, believing as they did Ms. G's version of these events? And if you can establish your allegation of sexual harassment, you can certainly use that as a defense. So by way of summary, you've got your route, the traditional route, the standard route of following a human rights complaint. You've got what I've labeled the really creative approach. Beware of it. Beware of Badaria. You've got creative traditional approaches, which is using existing common law approaches, and that is something that's bound to develop, and there are enough compelling situations out there that it's going to develop. And you've got the combination of using a civil action and a human rights complaint, and that is something which you should put an asterisk beside, because you want to watch how the law develops, lest your civil action be halted dead in its tracks. But watch as the law develops. The next time we're debating the issue of civil remedies for sexual harassment, it will be a little less esoteric, I promise you, because there are bound to be developments in the law. And as a footnote to this discussion, contrary to popular belief, I do not feel at all self-conscious about the unscheduled stretch break immediately following my talk.